Welcome to Law Day Live. This program is presented by the Chicago Bar Association. I'm Barry L. Gordon, a member of the Chicago Bar, and I have my own firm, Barry L. Gordon and Associates, in Chicago, whereby I practice and concentrate in family law, injury cases, and medical malpractice. To my left is Julie Eberhardt. Thank you for being here today.
My pleasure, Barry.
Who, like myself, concentrates in family law. She has her own practice, and her phone number is 312-212-3973. Today we're going to be talking about the nuts and bolts of divorce, custody, paternity, and child support, and all those matters that constitute family law and family problems. We'll be answering questions as to how custody cases are brought before the court, including types of custody cases, what does the court consider in awarding custody, what constitutes an unfit parent, what is joint custody, sole custody, and the rights of the custodial parents, and what a court-appointed lawyer is, and how much child support has to be paid, and who pays the attorney's fees, and what does a judge consider in awarding maintenance, previously called alimony. Before I go on, I want to invite you all to watch tomorrow, Thursday, April the 30th at 1 p.m., a program, again sponsored by the Chicago Bar Association, on landlord and tenant rights. And on Friday, May 1st at 1 p.m., a show on criminal law. And please understand that you can call the Chicago Bar Association at any time. They have a lawyer referral service. And if you are going to be watching this program, of course, it's CBA lawdaylive at gmail.com. Well, let's get started, Julie, and let's talk about child support. Is there any guidelines or formula, or do they ask each spouse how much you earn and what your expenses are?
Well, nowadays there's the guidelines in Illinois. It's a mathematical formula where you take a percentage of the parent who's going to be paying the child support, you take a percentage of their net income, and they pay it to the custodial parent. If you have one child, for example, you pay 20% of your net income. 2 children is 28%. 3 children, 32%, and it goes on from there based on the number of children.
So child support is set already by law, and you don't have to have anybody testify as to what their expenses are unless there's some unusual circumstance.
Right. It really streamlines the court process, saves the courts a lot of time, since you know if you're going to be paying child support for one child, it's 20% of the income. However, those are the guidelines, so there are special circumstances if there's a special needs child or considering the financial status of each of the parents. In cases like that, the court needs to make a special finding, and then they can deviate from the guidelines, and they will make an explicit finding as to what the reasons are for the deviation.
Now, I want to reiterate, this helps lawyers talk to each other and determine what the child support is going to be, so we can save the court a lot of time in having a court hearing.
Right.
It saves the parties a lot of time in not knowing what is their responsibility going to be if they file for divorce and so forth, and it just saves a lot of load for everybody. And you indicated that the court can deviate from these guidelines, but it has to say why. It
Right.
has to be specific, and that's the deviation that you just talked about.
Right.
Now, in custody matters, one of the parties can have custody and one or both can have joint custody. Can you explain what that is?
The primary difference between joint custody as opposed to sole custody is in regards to decision making. A lot of people seem to think that if you have sole custody, you get the child all the time and they never go with the other parent, and that's not true. For example, if mom has sole custody, all that means is that she is the primary decision maker when it comes to making educational decisions, decisions about medical expenses, medical procedures. Mom gets to make all of those decisions. Even if mom has sole custody, however, dad can still have as much visitation as the parties have agreed to or the court deems is appropriate for him, as opposed to if the parents are joint parents, then they have to make the medical decisions and the educational decisions together. And if they're unable to come to an agreement, only then the court would get involved. But it really focuses on the parent's ability to cooperate with each other.
So recapping, joint custody is not the sharing of a child or children, correct?
Not in sharing in time, no.
No.
It's not at all.
The child will live with one of those parents only.
Right. There'll be a custodial parent and a non-custodial parent.
And the reason is, I think going way back, we used to call them bag children.
Mm-hmm.
They would take their clothes in a bag to school with them because they didn't know if they were going to be with mom or dad, if Monday was mom's day or Tuesday was dad's day. And they also had two sets of rules. Mom had a set of rules. Dad had a set of rules. They had different clothes. Dad wanted them to wear nice clothes to school, and Mom said she didn't care. And so it was very conflicting for the children, and stability became a problem, and these children became psychologically affected. So I guess this is why we have joint custody where the child lives only with one parent.
Right.
And I want to say also that joint custody has to be where both parents are able to communicate and talk to each other.
Right. The court can't force parents to be joint parents. You
Right.
have to show to the judge that you can cooperate with each other, you can talk to each other, and you can put aside any differences you may have with the other parent and focus solely on the best interests of the child and working together for your children.
Okay, that all makes sense. Now, let's talk about awarding custody. What is the criteria, the best interest, something of that nature?
It is the best interest of the child. The court considers a handful of factors with regards to the child, primarily their mental ability to be facilitated by either parent. For example, if before the parents decided to get a divorce, mom was always in charge of taking the kids to and from school, making them dinner, helping them with their homework, the court's going to take into consideration that, maybe it would be best for the child and in the child's best interest for mom to continue to be able to do that. They'll also take into consideration how the parents are able to get the child to and from school, what the parents' work schedules are, common sense kind of things that would impact the life of the child.
Okay. I know that this is a call-in show. We don't use the telephone, but you can email us at the address I gave you at the beginning of the show, which is the CBA Law Day Live at gmail.com. And we do have a question that has been emailed into us. Steve, our associate there, you want to tell us what that question is?
Yeah, the question is, what do you enjoy most about family law?
You want to answer that, Julie?
I'll take that question. I enjoy family law because, I've always heard the saying that in family law, you get to meet some of the best people in the world at the worst time in their lives. And being able to help someone through a situation, whether it's a divorce or a child custody matter or, any of the family law issues that we face, you get to work with people and make a difference not only in their lives, but in the lives of their children and their spouse. And at the end of a case, I've had clients who come up to me and are so thankful they're crying or they want to give you a hug. And, it's just such a rewarding experience to know that you have really changed someone's life for the better.
I think that's the best answer I've ever heard. I commend you on that. But I'd like to just add on that I got a letter 5 years ago from a client that said to me that she has 3 children by her husband, and she came to see me, I think it was 15, 20 years ago, and I told her that I didn't think she was a candidate for divorce, and I said maybe you guys ought to save your money and go on a cruise or go on a trip together, and she did do that, and she saved her marriage. And thanks me for obviously having 3 children and a great family. So that's really what it's all about, and I think that's very important. Your answer is just like mine in the sense that we want to help people, and I think that's a good thing. Let's talk about children. Do they have any say-so in a divorce court, when it comes to who they would like to live with?
It really depends on the child's age. There's no set law that says once you're 14 or 15 or some determined age that you can come into court and testify. But the judges do take into consideration the wishes of the child. That's one of the factors in the best interest standard. There are a couple of different ways that children can become involved in the court process. Depending on how young they are, sometimes the judge likes to speak to them personally in an in-camera kind of setting with just the judge and the individual child, or there are a couple of different options on where an attorney can be appointed by the court to represent the child separate from the attorney relationships that are involved with the parents.
Okay. Now, usually I think the court will not interview a child unless the child is 11 years of age. Is that a true statement?
It's pretty standard, yes.
Okay. And you use the phrase in camera, and that's a legal term that we use, which means that the court, being the judge, will take the child into the chambers and interview the child himself or herself. And sometimes, if it's necessary, the judge will have little teddy bears and other stuffed animals around in order to facilitate this type of questioning. All right, let's talk about what's an unfit parent.
Well, an unfit parent is pretty much exactly what you would think it is. Someone who is incapable of parenting their child, whether it be because they have drug dependency issues, alcohol, they're just not around, they don't have the time or desire to parent their child. I mean, pretty commonsensical issues.
Okay. And what about appointing a lawyer for the child? I hear so much of that, and it's done every day in the courts. Why would something like that be done by a judge?
Sometimes you get into a situation where the child seems to kind of parrot whatever the parent is telling them, and parents obviously have a lot of influence over their children. So sometimes the courts want to appoint someone that the child can feel completely comfortable with talking to and saying, you know, if they do have a preference as to which parent they would live with, or if there are concerns that they may be able to express to someone who is not mom or dad, and then that person can address their concerns with the court.
Okay. Now, there's three types of lawyers, and actually one's not a lawyer, that is appointed to, I'll use the phrase, handle the child. What are those three types?
Well, there's a guardian ad litem for the child, which is someone who's appointed by the court to give a recommendation to the judge. They would meet with the child and with the parents and make a recommendation to the judge as to what is in the child's best interest, whether it's pertaining to custody or maybe it's switching schools or, you know, any child issues. There is also a child's representative, which is the attorney for the child, who represents the child and their interests separate from mom and dad. They have a relationship just like any other attorney-client privilege. They are not allowed to tell the judge or any of the other attorneys what is said in confidence unless, of course, the child then waives the privilege and, you know, says that it's okay and that they would prefer the attorney to be the one to talk to mom or dad or the judge.
Okay. Now, we have in Illinois, used to be called alimony. It's now called maintenance. You want to explain what maintenance is?
Maintenance is essentially spousal support. So it's payment from one spouse to their former spouse for anything for food, shelter, basically to support them now that the parties have split and are no longer living on a combined income.
Okay. Prior to January 1st of 2015, in order for a judge to award maintenance, there were certain characteristics that he would take into consideration. That's before January 1st. Do you have a recall as to what they are?
Yes, those were specific factors. They took into account the income of both parties, the earning capacity of both parties since the marriage had happened, what their ability is to earn outside of the home post-divorce, the duration of the marriage, how many years they had been together, the typical standard of living that the parties enjoyed during the marriage, whether they were vacationing every year or kind of living paycheck to paycheck. They would take into account any agreements that the parties may have made, and basically the catch-all factor of any other factor that's just and equitable. So they can consider a lot.
Okay, now as of January 1st of 2015, this year, the state legislature did a very drastic thing, and they changed all the laws regarding maintenance. Again, before it was called alimony. and they put it into a formula just like we have in child support.
Right.
Can you give us just an outline of what that is?
Basically, the way that works is they take into consideration the income of both of the parties and the duration of the marriage, and they put it into a mathematical formula that tries to equalize the incomes between the two individuals without overcompensating and giving more money to basically the spouse who would be receiving the payments as opposed to the spouse who's paying.
And as us lawyers look at this formula, we are really amazed. In fact, we don't even know how it's going to work because it just seems so drastic without taking into consideration who the parties are.
Right.
And it's a formula that basically says that it would be you take 30% of the gross of the payor, that's the person who's going to pay it, and you subtract 20% of the gross of the person who's receiving it, called the payee, and that figure that you get after that, that product of that figure, cannot be more than 40% of the combined gross. And then they have a schedule that tells you if it's 0 to 5 years, the marriage, or 5 to 10 years, or 10 to 15 years, what percent of those years that this would be paid. And that schedule's laid out in the statute. But the saving factor is that the judge does have full discretion to throw that statute aside if he feels that this is not a case that is subject to such a formula. Certainly, if somebody makes $3 million a year, and there's the spouse is also making a great deal of money, I don't think it would apply in that type of a situation. But that is a discretion that the judge has. We talked about child support. We talked about maintenance. Let's talk about attorney's fees. I get clients, and I'm sure you do too, that come into the office and say, I want a divorce, but I want him to pay for it.
Right. The very typical thing that happens is what they say is, well, I didn't want it, he wanted it, or she wanted it,
Right.
So if we're going to do this, then they should have to pay for all of it. Unfortunately, that's not the way it works. Attorney's fees are something that you can go to court and you can ask for, but if you've ever been through the court system, things don't happen in one court appearance. You don't just go to court one time and ask for attorney's fees and get a yes or no answer, and if it's yes, here's the amount. So you may spend 3, 4, 5, 6 court appearances trying to get the attorney's fees that you asked for, and on the first court date when you ask for them and you ask for X amount of money, by the time 4 or 5 court dates later you actually get it, you've actually wound up spending 4 times the amount that you asked for.
That's right. And you try to explain that to a client, it's very difficult because their only objective is they don't want to pay 1 penny for the attorney's fees, yet they want the spouse to pay for it, because obviously it's the spouse that caused all the problems, always is, and it just doesn't work that way. Let's talk about now if you want to move out of state. Let's say that you are the wife, there's 2 children involved, your husband and you live here in Illinois, and you want to move to Kentucky. What are the chances that that's going to happen?
Well, it's an uphill battle, that's definite. That being said, it's not impossible. If you are trying to move out of state with your children, you're going to have to prove to the judge that you have a good reason, not only that benefits you, but more so that benefits the children. Whether it's you got a promotion and there's a better job in this out-of-state area, it can't be something, that's all about you as my new fiance is living out there, things of that nature. The judge will also take into consideration whether, in your example, if it's mom that's leaving, what is she willing to do to continue to facilitate the relationship between the children and their father. If she's going to be the one who's kind of adding this burden into the situation, what is she going to do to alleviate some of that stress on not only the children but on dad?
And sometimes we have to, in order to get it past the judge, for him to decide in favor of the one spouse moving out of the state, we have to show how this is not going to deny the other spouse visitation.
Right.
Which is very important, and sometimes we have to strike a deal, so to speak. For example, if mom wants to move to Kentucky, maybe mom will pay for the airfare to and from, if she can afford it, sending the child back and forth, assuming the child's over age 11 and can fly alone. Otherwise, she has to fly with the child.
Right.
And that can become very expensive. Or instead of the husband having the child for 2 or 3 weeks in the summer, let him have the whole summer. In other words, we have to present some situation where we will get an agreement between these parties.
Right.
And like you said, just having a fiancé or a boyfriend out in another state is really not going to fly, generally speaking. It has to be something that's really for the benefit of the child or the children. And it does, in effect, and this is why it's an uphill battle, like you said in the beginning, it does deny visitation to one of the spouses.
Right.
And that's a real problem. Now, and we find that 50% of the cases they do allow it, and 50% they don't. But all the facts are different in each case, depending upon what the reason is. What if a child decides that the child wants to live with mom and not dad? How do we handle that?
Again, it's going to go back to the best interest of the child standard, and they're going to take into consideration, well, what are the reasons that the child wants to live, with dad? Did dad just buy the child a new car? Does dad not have as strict of curfew rules? Does dad allow him to have all his friends sleep over on the weekends? I mean, all of those are very easy reasons that a child would want to switch, but is it in his best interest or what he wants? Those are sometimes two very different things.
Yes, and years ago I actually had a case where dad would only give the children pizza when they were over. And of course the kids just love that. And they got a chance, in fact, to stay for 1 week with dad, and every night it was pizza. And this was brought out in court, of course, and the wife would complain that to the judge that it was not a healthy food, and the judge would say it's got all the ingredients, all the vitamins in it. So we kind of were floored when we heard that. Yes, you're right. Those things do happen. And what about the custodial parent's misconduct? Could that lead to a custody modification? And you have to tell me what kind of misconduct, if any.
I mean, for that in and of itself to lead to a custody modification, it would have to be something that would endanger the welfare of the children. Obviously having excessive drinking, having parties, having drugs in the house, that would be something the judges would definitely take a strong look at and say, these people, this person is not fit to have the custody and control of their kids.
And we have the right as lawyers to come in and do a petition to have a drug test on the spouse that we suspect may be involved in drugs. And that drug test is a surprise test, so that spouse does not have adequate time to, quote, clean themselves up.
Right.
And I want to remind everybody out there that the viewing audience that you can obtain a lawyer through the referral service of the Chicago Bar Association. And remind you all that if you have a question and you want to email us, it's at cbalawdaylive@gmail.com. And we only have a few more minutes here to go. Let's touch on some other important subjects. And by the way, the Bar Association Lawyer Referral Service is 312-554-2001. And tomorrow, as I said at the beginning of the show, there is another show that will be on the air at 1 o'clock, Landlord and Tenant Rights, and Friday at 1 o'clock also Criminal Law, broadcast from the same room here today. We talked about maintenance, and maintenance, is that something that you have a right to? Even we got the formula that we talked about. We talked about the discretion that a judge has, but is there an absolute right to maintenance?
No.
Okay. In fact, if you had a marriage that was only 6 months long, probably a judge would reject you in having maintenance, because it knocks out the problem with some women who are 30 years old marrying men who are 85.
Right.
Hoping that they would die and that they would get everything and so forth. It's the same type of intent that they had as to when it comes to maintenance, you would want to marry somebody that's very wealthy so that you can get some support. But it would have to be a marriage of a long duration.
Right.
Some of the other questions that we would like is, can you modify custody at any time?
After you enter an initial custody judgment, you have to wait 2 years to modify it unless there are extenuating circumstances, like we talked about, endangering the child or dangerous circumstances.
Yes.
Otherwise, if you're making a custody agreement and agreeing to it, they want to try to keep everything as stable as possible after the initial divorce. They want the custody judgment to be maintained for 2 years to actually see how it's going to play out, how the visitation's going to go, and it's a very high standard to try to modify the agreement within the 2-year period. But after that, you can file a petition with the court and state your reasons for wanting to change it, and the judge will make the ultimate decision.
Okay. What about child support? Let's say the husband is paying child support. He's a non-custodial parent, and he gets a substantial increase in his wages. Now, can you come back into court and ask that the child support be increased based upon his net salary?
Absolutely. Absolutely.
Okay. And in order to determine what his actual wages are, we have what's called the discovery process. You want to explain what that is?
The discovery process basically allows the party looking for the financial information of the non-custodial parent to require them to turn over tax returns, pay stubs, to fill out basically a financial worksheet where they put all of their income, all of their expenses, and so that you can kind of compare the worksheet with the pay stubs, with the tax returns, to make sure that everything jives and there's nothing that looks weird. It makes it a little bit harder to hide any sort of income that you may or may not have. And then it gives you the numbers with which to calculate the 20% or the 28%.
Okay, so we can have all that produced at our office. And by the way, the public doesn't really realize it, but lawyers have subpoena power. If we're involved in a case, we could send a subpoena out without having a court permission to do so. Of course, we always have to do it under the guidelines of the Supreme Court rules, and we can't violate those rules at any time. This is something that's been kind of new, I think, in the last 5 years, something of that nature. All right, now, we have, you and I, I'm sure, both together have received many clients that are living with a new roommate, usually another new husband or a boyfriend, and there's always a conflict with the visitation when Dad comes over and wants to see the children, and there's this other guy around.
Right.
How do we handle things like that?
Well, I think the best way to do it is initially, especially at the beginning, is to keep your new personal life separate from that of your children. It's a very traumatic experience for children to go through divorce and be introduced to all these new situations as far as living, and sometimes it's changing school, that as much as you can keep the stability for the children, it's important. So adding a new boyfriend or a new girlfriend whom may be here today and not here 6 months from now. I never recommend to my clients introducing a significant other unless you have been separated, you are divorced, and you're really sure that this new person is going to be around for a while, whether you're going to get married or whatever it is.
That all makes sense. I want to thank, we're going to call this a wrap. It really went by fast.
It did.
And I want to thank you, Julie Eberhardt, and your phone number is 312-212-3473. And you concentrate in family law as well as I do, and it's been a great program here. We've talked about joint custody, we've talked about sole custody, we've talked about taking a child out of the jurisdiction, talked about all the nuts and bolts of family law. You can call the Chicago Bar Association at 312-554-2001 in case you need a lawyer. They have many categories that you can talk about. Tomorrow there's a show at 1 o'clock on landlord-tenant rights, and on Friday at 1 o'clock on criminal law. I want to thank all of you for watching Law Day Live. Julie Eberhardt and Barry Gordon. Thank you.